Could you take care of that? Thank you so much. So welcome to our first ADR webinar designed specifically for Oregon Circuit Court connected mediators and arbitrators. My name is Megan Hassan, and I'm the ADR Legal Policy Advisor with the Oregon Judicial Department. I'd also like to introduce Caitlin Jackson, our new ADR analyst. Many of you know her through her work in Lane County as a mediator and a trainer. And I'd also like to thank our MA, Emily Burgess, for coordinating all of the logistics for this training. We have a long list of topics that we'd like to bring you in the coming months over this online format, primarily directed at mediators, but from time to time, the topics will also be relevant to arbitrators. And when that's the case, we'll be sure to reach out to you and just keep you posted as these programs develop. But we're so happy that you're here today for our first one. Before we get started, I have just a few announcements. First of all, you are welcome to ask questions of the presenters by posting them in the chat. So there's at the very bottom right-hand side of your screen, there's a little bubble that you can press on, and that will open up your chat. Caitlin will be monitoring the chat for questions, and will be sending those or interrupting the presenters at appropriate times to ask those. It's also possible that we might just save those for the end, so we'll see what our timing looks like. Also, I wanted to let the lawyers in the group know that for continuing education credit, we need you to submit your name and bar number through a link that will be shared near the end of this session in the chat, or through a post-session survey that will be emailed to you following this session. And then we'll forward your info to the bar. Mediators can also use this session for their required continuing education hours. We're launching a new electronic system for courts who have asked us to provide support for reporting, and we're going to send out additional details about that in an email following today's session as well. So also just to let you know, we are recording the session. We want to make sure that mediators and arbitrators who couldn't make it today are still able to benefit from the information that's going to be shared. So turning now for our program for today. Most of you know that we've recently been able to expand access to court-certified interpreters for court-connected mediation in those cases that are mediated outside of the courthouse, as long as they're ordered or referred to mediation by the court. So now court-certified interpretation applies to mediations happening within the courthouse and also court-ordered or referred cases outside of the courthouse. And we were able to do that in large part due to the collaboration and support from Court Language Access Services, a division within OJD, and our guest speaker, Yvette, who I'm so excited to introduce now. Yvette Tamamoto is the Language Access Coordinator for the Oregon Judicial Department and is a subject matter expert on language access. She recommends, develops, and implements policy at OJD to ensure meaningful language access services to limited English proficient court customers. Welcome, Yvette. And Adam Bethune is a court certified Spanish interpreter and has been doing legal interpreting for about 10 years. He comes from a line of interpreters, and both his grandfather and mother are interpreters. We're so pleased to have you both here today. Go ahead and take it away.
I work for the Oregon Judicial Department as the Court Language Access Coordinator. So today we're going to talk about how to obtain interpreters for mediations and arbitrations and best practices when working for interpreters. As Megan mentioned, we'll be taking questions and providing answers in real time. So just place your questions in the chat and we'll make sure to address them. Also, we'll be emailing you a copy of this PowerPoint with other helpful materials. So at OJD, I work in the Court Language Access Services Division, sometimes known as CLASS. And our mission is to provide language access to the courts by using credentialed interpreters and translators and educating court staff and external court partners. Here's a chart of how the work we do fits into our mission statement. First, we have the interpreting services, and that includes our schedulers. And our schedulers schedule interpreters for circuit courts statewide. And this section also includes staff interpreters and contract interpreters. The next section is certification and training. That section does all the court interpreter credentialing, which includes administering the court certified interpreter exam. And now the third section, that conducts language access training for internal and external justice partners and makes sure that language access is available throughout the courthouse. Just to give you an idea of the number of requests that we do process, here's a chart showing how many interpreter requests were processed for the past 5 years. I also wanted to show you the different languages we work with. So back in 2022, we scheduled for 117 different languages. And since we've been counting and keeping track, we've actually worked with 250 different languages. Okay, so getting started, the overall goal of this presentation is for mediators and arbitrators to be able to provide language access to limited English proficient court customers. As Megan mentioned, this year there was a slight change in the OJD policy, and the revised policy allows OJD to provide court interpreters where the court has ordered or referred a case to mediation, and as long as the mediation is not conducted by or through another state agency, for example, like DHS. The policy was revised, so we revised this policy so that we could address situations where the court is requiring parties to mediate, but the mediation is being conducted outside of the courthouse by a private mediator, a nonprofit, or through a county mediation program. OJD will continue to provide court interpreters in cases where the parties participate in an approved court mediation program that is an alternative to mandatory arbitration. Some things I hope you'll take away from this presentation is to know how to connect to a language line interpreter for initial contact or intake needs. Know how to request for an interpreter through class for court-ordered mediation and arbitrations. And to learn best practices when working with an interpreter. So let's start with language line. We're going to discuss when and how to use language line and go over the basic instructions. So language line is an on-demand remote interpreting agency that OJD contracts with. Language line is not OJD or class, but a company we work with. And the appropriate time to use language line is for initial contact with the court client, for example, when you're scheduling your appointment or when conducting an intake interview. Language line should never be used for the actual mediation or arbitration. And the reason for this is that although language line vets their interpreters, they may not be court certified and they do not go through OJD's court credentialing. So language line is really easy to use. The basic steps are you would dial the 1866 number and listen to the prompts. You enter this specific client ID number. Press 1 for Spanish or 2 for languages other than Spanish. And then enter your 10-digit phone number that you're calling from. Once you're connected with the interpreter, they might ask additional questions like the county and case number. The reason we're asking for this information is so that we can identify and verify the mediator or arbitrator. So when you're using language line and connecting to the client by phone, I also recommend that you connect with language line first. That way you can let the interpreter know what the phone call will entail. Give them a brief description of what this phone call is going to be about. And the instructions for how to use language line will be part of the materials that we will be providing. So the language line client ID number that you provide is very unique and is only for OJD cases that has court-ordered mediation or arbitration. I cannot stress, do not share this phone number with anyone with, this is particularly specific and will be monitored for just mediation arbitration cases. So let's move on to requesting an interpreter for the actual mediation or arbitration. To do this, you would use the OJD online request form. If for some reason you're not able to get to the request form and only as a last resort, you can email a class regional scheduler. We will be providing the email addresses in the PowerPoint materials. But I want to emphasize that the request form is the fastest and most efficient way to request for an interpreter and the preferred way. Class provides interpreters for spoken languages and also for American Sign Language. So let's go over where to locate the online request form and what information is needed. The online request form is located on the OJT website. When you get to the main page, you would click on the How Do I, and a drop-down will appear. From the drop-down, click a Request an Interpreter, and that will take you directly to the request form. Once you're on the request form, the scheduler only needs certain information to process the request. A list of the exact information that's needed on that request form is to be filled out is on the instruction sheet that we will be providing. So remember, just what's on that instruction sheet, that information is what needed. There's going to be other questions or other places that they might ask for other information, but that doesn't need to be filled out, only what's listed here. When you need to email your requests, use these emails provided. The emails are listed according to the region. So to locate which email to use, find the county that you are conducting the mediation or arbitration for and use the corresponding email. But again, we prefer that you use the online request form. So if for some reason you need an interpreter at the last minute, class may be able to still get you an interpreter. And it's going to be mainly only for any Spanish interpreter needs. It's a little harder to get languages other than Spanish, but for Spanish, we do have like a lot of interpreters that are scheduled that day. So we may be able to get you one. When they're assigned, class assigns the interpreters on minimum blocks of time. So when they're assigned, for example, a 2-hour block and the actual hearing that they're assigned to only lasts for 15 minutes, they are still available to us for another hour and 45 minutes. So the best way to request for a last minute interpreter is to send in the request form, as they may have an interpreter that is available and they can either, they might be available to come in person or they might be available just remotely or by phone. And the reason we ask you to use the request form is that it goes directly into the scheduler's inbox. And it also indicates that it's last minute, so they will look at that request right away. And again, I want to emphasize, do not use language line for the actual mediation or arbitration. Sometimes the client may bring in a family member to assist, them with the interpretation, and we do not recommend using family members. There may be like some unseen barriers, such as contentious family situations. There's no guarantee that the family member will not be biased or provide accurate information. Also, we need to provide the LEP court client language access that will give them the opportunity to actively participate. Again, do not use language line. If an interpreter is not available, you may need to reschedule the mediation or arbitration. So let's do a quick recap. Language line is only to be used for initial contact and intakes and not for mediation or arbitrations. The language code is assigned specific to mediators and arbitrators, so please don't give it out. The online request form is the most efficient way to request for an interpreter. Family members should never be used for mediations or arbitrations. If you have a last minute interpreter need, the online request form is the fastest way to request for an interpreter. So my coworker, Adam Bethune, is going to join me. Adam is one of our OJD staff interpreters with class, and he usually works out of the Multnomah County Courthouse. So we're going to demonstrate 3 modes of interpreting: simultaneous, consecutive, and sight translation. I just wanted to give you an idea of what an interpreter looks like when they're interpreting. I'm sure a lot of you worked with interpreters before, but just to show you a little bit of the three modes and the different types. So we'll start with simultaneous. An example of when they use simultaneous interpreting is when the interpreter is interpreting for the parents, like of a juvenile dependent. It's when an interpreter interprets from English to the non-English language in real time. So for simultaneous, and so that everyone doesn't hear both of us speaking, I'm actually gonna call Adam on his phone. Oh, I'm actually, no. Yeah, I'm gonna call Adam on his phone, and I'm gonna mute myself.
Exactly, and so you'll hear, good afternoon, everyone. This is Adam Bethune. I'm the Spanish staff interpreter at Multnomah County Circuit Court, and nice to meet all of you. But so she's going to call me in a moment, and I'm going to render my simultaneous interpretation as I hear it through my headset to you over here, over the speakers in Spanish, and just give you a little bit of an idea of what it's like. Give us a moment. Can you hear me a bit? Okay. Yeah, Yvette asked me to explain to all of you that this is, if we were doing this virtually, if class was providing an interpreter for a remote hearing, this is sometimes how we would do this virtually. In other words, sometimes we're connected with a judge who's in the courtroom, who's also connected virtually to this call. And sometimes we're asked to call the LEP parties who can't connect to the WebEx on a separate line, like such as our phones. Maybe through like WhatsApp or even directly to their phone number. And then we consecutively or simultaneously interpret what the judge or the other parties are saying to them, to this LEP party over the phone. So this probably won't end up happening with one of our arbitration or mediation sessions, but it could very well happen if it was something that was short. Just as a, yeah, I'm ready. Esta audiencia se llama una lectura de cargos. Se le está acusando con la comisión de un delito. Estoy asesorando de sus derechos. Tiene derecho a un abogado. Tiene derecho a comprar boletos de lotería. Si ganara, no le corresponde un defensor público. Le corresponde comprar un convertible rojo. Tiene derecho a un juicio. En un juicio, si quisiera, podría declarar y decir su versión de los hechos, pero puede que no quiera contarlo todo. Entonces puede decidir no hacer nada y dormirse en los laureles, concluir su caso y citar la jurisprudencia que sustenta su posición, a pesar de que sea insostenible, o jugar el tenis o citar Tennyson. Véase RCW 2.42040 y 113 WN2D 486. CJS, ALR, ABC, y QZ8. So at the end there, folks, if you were listening or kind of following in Spanish, it just sounded like I was just reading off letters and numbers, and that's just sort of like when they're quoting Oregon revised statutes, subsections and sections of Oregon revised statutes. So sorry if that sounded a little bit awkward at the end, but that's sort of how simultaneous sounds. When it's very fast, it can sound a little bit monotone and a little bit boring, depending on the skill of the interpreter as well. But that's how we would typically render it. That's typically how it's rendered in the courtroom when the judge is addressing one of the parties too. It just gives you an idea of the speed. Yeah.
Okay.
Okay.
Thank you, Adam. Next, we're going to do the consecutive, and I'm going to share my screen with regarding what I'll be reading. So let me share you that screen. And Adam, tell me when you're ready.
Just to recap, the consecutive, let me see here, the consecutive is when the interpreter waits until the speaker has finished before rendering
I think
speech
you're on
into
mute,
another.
Adam. And Just to let you know, consecutive interpreting we usually use for witness testimony. It's usually what's so that they can hear clearly what's on the record.
Can you hear me now?
Ready,
Yvette?
Adam?
Hello?
Adam, I can hear you. I'm thinking maybe Yvette's sound might be turned down, so I'll message.
Okay, one moment. Yeah, thank you.
Oh, are we good?
Can you hear us, Yvette?
Yes, I can hear you now.
Okay. Yep. Okay. Yeah, I was just gonna add to what you were saying that typically consecutive is preferred for like a for let's say like a direct examination or a cross examination because it's done a little bit more slowly and deliberately. It's easier to preserve like the register the intent of the speaker. So it's the preferred mode of interpreting when it comes to those kinds of situations. Yeah.
Okay, you
Anyway.
ready?
Yep.
Okay.
Okay.
Well, sorry. There were 3 passengers in the car northbound.
Había 3 pasajeros dentro del carro que iba rumbo al norte.
The driver seemed to be a tall, red-haired man.
Y el chofer era parecía ser un hombre alto, pelo rojo.
Mr. Taylor was sitting in the passenger seat, and right behind him was the woman I also saw at the pharmacy the day before.
El señor Taylor iba sentado en el asiento del copiloto y justamente detrás de él iba la señorita que había visto en la farmacia el día anterior.
They were going about 35 miles per hour, but then they turned on the 45th court and pulled off to the right.
Ellos iban aproximadamente 35 millas por hora y luego doblaron a la derecha en la calle 45th Court y luego se orillaron a la derecha.
Perfect. Thank you, Adam.
Mhm.
Adam is also going to give a quick example of the site translation. Site translation is when they're provided a document and asked to, they usually take a look at it for a few minutes. It might be in Spanish or it might be in English that they need to interpret for the LEP court customer. They're giving a few minutes to look it over and then they will interpret or site translate it to the court customer.
And I wanted to tell all of you too that it's not unusual, like if it's a very difficult legal document that has a lot of difficult legal language, it's not unusual for the interpreter to need a little bit extra time to look it over and to render that document. I mean, we are expected to know like some of the basic court documents, but don't see it as something strange. In fact, you should see it as a sign of professionalism. If an interpreter asks, "Oh, could you give me a little more time? I may need to look up a term or two." When you have like a form or something like that, a paragraph from something that needs to be read to them, and the interpreter is just unfamiliar with it. So,
Thank you, Adam.
of course. Take a look at what we're doing here. Okay, so we're gonna put up the site interpretation exercise. Could you do that for me, Yvette?
Yes.
Thank you. Let's see here. So this one's with, typically it's something that we haven't seen before. That's what a true site interpretation is, but sometimes it's something that we've seen before as well. And it also never hurts. Like, let's say there's going to be something used that the interpreter may not have seen before. You may want to show the interpreter beforehand as well, so the interpreter has a chance to look it over, because it never hurts to be well prepared. And so in this case, we're dealing with an explanation of the grand jury. Let's see here. Essentially, it's like the grand jury rights or an explanation of the grand jury procedure. Okay. So I would take like maybe like 1 to 2 minutes to read through this, and then I would begin rendering. I'm just going to start rendering it because I did a little bit of practice before. So let's see here. La formulación de los cargos. Después de que el fiscal estudia los hechos de los investigadores y los hechos que hayan recabado al hablar con los individuos involucrados, el fiscal decide si quiere exponer su caso al gran jurado. Cuando una persona es acusada formalmente por el gran jurado, esta persona recibe una notificación formal de que el gran jurado piensa que probablemente esta persona haya cometido un delito. And so I'm pretty much now, at the part where it says it is believed that they committed a crime. So I'm just going to keep going here, where it says the indictment contains the basic information. La acusación del gran jurado contiene la información, los hechos esenciales que sirven para informar a la persona de los cargos que se han formulado en contra de ellos. Para una posible acusación de delito mayor, un fiscal presentaría pruebas a un grupo de ciudadanos imparciales llamados un gran jurado. So now I'm where it says witnesses may be called to testify. Puede que a los testigos se les llame a declarar a los testigos que el fiscal presente pruebas al gran jurado y un resumen de los hechos del caso a los integrantes del gran jurado. El gran jurado escucha al fiscal y a los testigos y luego votan en secreto acerca de si creen que haya suficientes pruebas para formular cargos contra una persona. Right? And now I'm at a grand jury may decide not to charge an individual. Let's see here. Puede que un gran jurado se abstenga de formular cargos contra un individuo basado en las pruebas. En ese caso, no se emitiría una acusación del gran jurado. Todos los procedimientos y declaraciones hechos ante un gran jurado están sellados, o sea que las únicas personas en el cuarto que tienen conocimiento acerca de lo que se dijo, quién lo dijo y de quién se trataba, eran esas personas. Okay, so we're at the final sentence now where it says, where are we? The grand jury is a constitutional requirement. Okay. Let me see. La Constitución de Estados Unidos requiere la convocación de un gran jurado para ciertas clases de delitos. Okay. Por el hecho de que ninguno de los integrantes del gran jurado conoce al sospechoso, al votar sobre la formulación de los cargos, este requisito constitucional garantiza la imparcialidad de la votación. Okay, so I just finished up there. That one was a little bit more difficult. Some of the required a little more restructuring at the final sentence, but it's not unusual for the interpreter sometimes to take a few pauses there too, if it's something that's unfamiliar to the interpreter. So don't be too surprised by that. Yep. That's the end of it.
Thank you very much.
Of course.
Let me go back to the.
Are there some other points that I can make, Yvette, really quickly about interpreting to the arbitrators and the mediators here? Would you mind? We have time?
Go ahead, Adam. Go ahead.
Okay. The other thing I want everybody to keep in mind is when they're dealing with an interpreter and with an LEP party, the LEP party may not be accustomed to how a court uses an interpreter or how a court interpreter functions. In other words, like the court interpreter may need to let the LEP party, with the permission of the mediator or arbitrator, know that there's going to be a certain flow to how the consecutive or the interpreting is done. And the interpreter may need to raise their hand on the screen, right, if it's being done remotely, so that the person knows that the interpreter needs a pause in order for the interpreter to be able to catch up to what's been said. So the arbitrator or mediator may just have to let them know, hey, look, the interpreter may need some pauses, and just be on the lookout for them to raise their hand. Let me see what else I was going to say here. Let me see here, but that's mainly the I think that was the main point. And then the other point as well is if it's a long mediation session, a very long mediation arbitration session, and there's only one interpreter present, interpreters are not machines, right? Nobody's a machine, right? And the quality of our interpreting actually has been proven by neuroscience to go down substantially after 30 to 40 minutes of continuous interpretation, regardless of the level of quality of the interpreter. So it's very important for us to take regular breaks, especially if we're by ourselves. Like every 30 to 40 minutes is what's recommended for us to take a short 5-minute break as well. So don't be surprised if an interpreter is asking for breaks every 30 to 40 minutes if they're by themselves. If they're asking for breaks every 10, 15 minutes, that may be a little bit unusual. And it's also okay for an interpreter to ask for clarifications as well. Like sometimes we encounter words and phrases that may require clarification, but we should always ask you for permission to do that first as well. So, I mean, this is all just to improve the flow of things, like for everyone involved. Sometimes interpreters don't do a good job of relaying this to the arbitrators and the mediators as well, that they need breaks, or they may need a clarification, or they may just be unfamiliar with the language and they need to look it up. So I just hope that you keep some of those things in mind. And I've worked with many arbitrators and mediators in the past. It's always been a pleasure. It's actually one of my favorite things to do, working with the mediators and in those sessions. Very rewarding. If we can resolve a case right before it goes to trial, I think that's a very good use of state resources. So I applaud your efforts, and I hope to work with all of you in the future at some point. That's just all I wanted to say.
Thank you very much, Adam.
Of course.
So I'm going to go over some best practices when working with an interpreter. And Adam, if you want to chime in as I go down, please feel free to. As you can tell, he's been interpreting this morning. So I do want to give him a little break. But if you can chime in, if you see wherever you see fit, I would really appreciate it.
Of course.
So one of the best practices is to ask everyone to speak clearly and also one at a time. At the beginning of your session or at the beginning, allow the LAP court client to speak with the interpreter. That way they can make sure that they understand each other. Speak to the LAP court client, not to the interpreter. Use plain English. And be aware of how loud and fast you're speaking and the amount of sentences you're using without giving the interpreter time to interpret.
And then just to chime in there very quickly, so we as professional interpreters, if we are talking to you or asking you a question and we're kind of out of the role of, whenever we're speaking and the mediation session is going, whatever you hear us say is what the other party is saying. And so in order to avoid confusion, if we need to pause the session and we need to talk to you or ask you a question, we should always refer to ourselves in the third person. So don't find it unusual. You shouldn't find it surprising if the interpreter all of a sudden says, "Oh, the interpreter would like a break," or "The interpreter would like a pause." That's how we should refer to ourselves when we're talking to you or talking to anybody, so that you don't confuse our speech or what we are saying with what the participants are saying. Keep that in mind.
Perfect. Yep. Thank you, Adam. I'm going to go over some best practices when working with an interpreter remotely. Send a link ahead of time if you're using some kind of virtual program, Zoom or WebEx. And actually, one of the questions in the request form, we'd like you to is notes, and we'd like you to include the link so that we can make sure the interpreter has that ahead of time. Do a brief sound check. We ask that you make sure everyone can hear each other, and a good way to do this is to introduce everyone at the beginning, who's who, and also to do that language assessment. You should also ask participants to mute their line when they are not speaking. That way, if there's other noises going outside within wherever they're at, like in their home, that it doesn't distract and other people can't hear what's going on. Also, ask everyone to speak one at a time, and ask the LAP court client to let you know if they can't hear or understand the interpreter.
And then conversely, like if the interpreter can't hear the LEP parties because of some background noise, the interpreter might just let you know, oh, hey, the interpreter has an impediment to proper interpretation or to accurate interpretation because of the background noise. Could Madam or Mr. Arbitrator, Mediator, could you please ask the LEP party to move to a different room, or to ask the people that are making noise to keep the noise down, something like that. Yeah.
Perfect. Thank you. Other tips? Inform the interpreter to let you know as soon as any connectivity issues come up. When you're working with an ASL or an American Sign Language interpreter, we ask that you pin them in one location when you're using them remotely on the video. That way they always stay there. They're interpreting the whole time. Their face doesn't disappear maybe when someone else is talking. So to pin their video in one area. And if you're using an interpreter telephonically, ask everyone to briefly identify themselves before they speak, as it might be hard to recognize everyone's voices. Do you want to talk a little bit more about that, Adam?
Yeah, I can talk a little bit more about that. Yeah, especially if there's multiple parties, and we all like, and just like in common everyday speech, when we're talking and relating a story, we often use pronouns as well. We tend to revert into this over excessive use of pronouns, but it's a normal part of everyday speech. But if we can't, if it's multiple parties or they're referring to multiple people in their version of events, they may need to specify, or the interpreter may need to ask for a clarification. I mean, this is also for purposes of interpretation as well, not just for purposes of identifying everybody. It's kind of is a bit of a pain to have to identify yourself every time, but it certainly is very helpful if there are, especially if they're on the same line or like they're on the same video. It's always helpful, I think, definitely.
Perfect. Thank you. So what court interpreters never do is they never offer an opinion. They don't give advice. They don't summarize statements or omit or add information. Anything else you want to add to that, Adam?
Yeah, sure. Let me see. Just whenever we're having, let's say like I ask for a clarification, I ask that the mediator allows me to clarify a word. I shouldn't be having a side conversation with the person, or it shouldn't be going on for too long. If you feel like it's going on for too long, just let the interpreter know. Oh, hey, could you let me know what's going on? Do you mind? I just don't know what's going on. Or if something like that, right? There shouldn't be any sort of like signs of familiarity either. Like for example, if we know the person, we should let you know, right? If they're an acquaintance of ours, we should immediately let the court know that this could be a conflict of interest as well. Let me see here, giving advice. Let's say like a common thing that happens all the time is the person may ask the interpreter directly, what do you think about this? What's your opinion? What do you think? What should I do? That happens all the time. And so the correct procedure for us is just to let you know, we should first of all let them know that we're interpreters and we're neutral, and that we're going to relay any questions that they have to the mediator or arbitrator. And then the next step is to let you know what the person just asked, be it, oh, like they had a question related to the case, they want to know if that's the best option, or this, something like that, right? So we should never be giving advice, certainly not giving advice, and we should definitely be emphasizing that we are neutral parties. It should be very clear to them. Trying to think of adding any information, but I think that's all I wanted to add on that one.
Thank you. Thank you. So, Caitlin, was there any questions? Does anyone have any quick questions or anything else we want to follow up on?
Yeah, I have a couple questions that folks have sent in the chat. So the first question is, if a party shows up to a mediation or arbitration and the mediator or arbitrator thinks they may benefit from having an interpreter present, do you have any recommendations for how to know when it might be appropriate to offer interpretation services without making assumptions or causing harm for the party?
Well, that's always a hard one because you don't want to offend anyone. You don't want to, and we get that question quite a bit. Um, how I, you know, I try to find to grace. I try to find a way to gracefully offer it, like choosing words like maybe Adam, how I kind of just would you need not would you need, but would you like to have an interpreter present? Will that, choosing your words in a way that doesn't make them feel offended, because we've
Oh,
come
I see.
into
It's
that.
like if it, so again, can you say the question one more time? It's like, let's say like it's a person that may need an interpreter and the mediator arbitrator may want to ask them, like, do you
Yes,
need an interpreter? How do you ask that?
without offending them. Yeah.
Um, without offending them, should think. Like, is it, I mean, it just depends on the context, right? It could just, you could also say like, um, if you would like, I'm just trying to think of the context, but,
We
sometimes
say
sometimes I was going to start, sorry, but I can say sometimes you could even propose like a hybrid mode too, which is kind of like, you know, if you feel you have difficulty understanding me or you require the use of an interpreter, we can always provide an interpreter, and the interpreter could even be there just as somebody that clarifies, when difficult terminology comes up, they can just interpret difficult terminology, something like that. It could just be in a limited fashion. um, I mean, it just depends on the judgment of the mediator or arbitrator. Um,
I would say something to like,
mhm.
if you think throughout this arbitration or mediation, if you think you need an interpreter, just let me know. I mean, something like that. I would say it very gently though, because we have offended some people when we've asked when you straight up ask, hey, we can provide you with an interpreter, and it's like, no, I speak English well, and so maybe something like that. If you find, and and explain, an interpreter won't be like they won't advocate for you, but they may help you with some of the legal terms that we'll be talking about. Something like that. That would be a good response.
Thank you. And we had one person write a comment that just says, I will sometimes ask folks what language they feel most comfortable mediating in.
There
I've
we
also
go.
heard from mediators, this is a time to be attentive to your intake forms. So you may want to ask before you schedule the session, does anyone need an interpreter? That way everyone has had the option beforehand to request that service. Another question we received is, and we've gotten this kind of a couple times, someone had a case where we requested an interpreter, but the party ended up saying they were okay to participate in English and just wanted the interpreter there on hand if something came up that they needed interpreted. Is that okay?
Yes, we would schedule for that. It's sort of like what Adam was mentioning. Maybe there's some legal terms that don't necessarily translate English into their language. They might need a little bit more clarification. Not advocating now, don't get me wrong, but I mean a little bit more descriptive words to describe what we're trying to say. So we can provide an interpreter for that to be like on standby.
And
Okay.
it always comes back to the mediator. Like we should always like it always should be through the mediator. Like the interpreter shouldn't be like independently clarifying things. For example, like the person, if we're there just kind of like on a consultation basis or just to interpret difficult terms, it may just be our part to just say the interpreter, just heard the person say they don't understand this term. Could Madam Mediator, Mr. Mediator, please provide a clarification or explain what the term means, something like that. But it should always be through the mediator that we're explaining to you. We shouldn't just be going off on our own.
Okay,
Kind of
thank
thing.
you.
Yep.
And if someone has requested an interpreter but then starts speaking English midway through the session, any recommendations on how to handle that?
And that does happen. Adam, you want to explain when that happens in that situation?
It depends. Like, is it confusing? Do you think that probably would be confusing for the mediator and the arbitrator, right? It may be confusing for the mediator and the arbitrator. Well, I have quite a bit of experience with like dealing with that in like depositions, for example, and typically the attorneys will just instruct, like, let's say like they have their attorney there present and they're being questioned by the insurance company's attorney. The attorneys will say, like, could you just try to stick to one language? I know it can be difficult, but like for the purposes of the mediator's understanding and also for the purposes of the interpreter, it just goes more smoothly when you just do it in one language. It avoids confusion and it's more smooth in one language. And we're not trying to offend you or anything, or not trying to tell you how to speak, but just for the purposes of like the record and for everybody's understanding, it's easier when it's just done in one language. I mean, there's only so much you can do, right? If the person just keeps doing it over and over, you just have to work with it the best that you can. I mean, it's happened to me many times in like depositions and sworn statements, that the people will go between the two languages, sometimes in one sentence in one and the other, and they just have to be reminded politely that, you know, just for purposes of interpretation and understanding, please just try to stick to one language. That would be my recommendation. Just be polite about it and just do the best that you can.
Okay, thank you. And I'm seeing some folks put some other tips for how they've handled things in the chat. So if you can't see the chat, it looks kind of like a text bubble, and on my screen, it's on the lower right-hand corner. So feel free to read through those too.
Yeah.
Our next question is, would it ever be appropriate to have one party in a mediation or a party in a case interpret for another party? Kind of similar to someone brings a family member, but in this case, someone is just saying I'll mediate or I'll interpret for them.
You know,
Yeah.
for the actual arbitration or for the actual mediation, we'd like you to use court interpreter. They're credentialed, they're certified. Spanish interpreters are certified. Other languages may be certified, registered, but they're credentialed. And so we'd rather you use one of our interpreters. And I forgot to mention that it is optional. If you wanted to use your own interpreter or hire your own, that is your prerogative, but we are offering this service, this interpreting service, at no charge. And we do, when it comes to court arbitrations and mediations, we do recommend you using our court interpreters.
I would be very careful about that. Yeah, if it's a family member, because there's no guarantee in terms of neutrality and impartiality. Like if you're an interpreter, right, a court certified interpreter, it's unlikely that you know or have any interest, right, in the outcome of whatever the mediation is. But if it's a family member, they have an interest, right? You can't guarantee their neutrality and impartiality and what they're going to say. Like even with the best of intentions, they haven't been trained, right? They don't know how to deal with the modes. They don't know how to deal with clarifications, asking for breaks. They don't know some of the court terminology as well. So it's a big risk. You're risking a lot there. Unless the person that they hired privately is certified interpreter in this state or another state. I mean, in that case, I would just ask them to establish their credentials, like their first and last name. What is their experience? Things like that. Where were you certified? Were you certified by the National Center for the State Courts? Do you have a state certification? That's typically the national body that certifies interpreters, National Center for the State Courts. So you could always ask them that as well to establish their credentials. Yep.
Thank you. The next question, is it appropriate or expected for the interpreter to mention that a statement seemed intended as irony, satire, or to otherwise explain the tone that was intended?
See, it's a bit of a judgment call. It's a judgment call on the part of the interpreter, but sometimes it can be necessary if the interpreter feels like that just saying it as it is not properly conveying, or for example, they don't have the perfect term that they need to be able to translate that, and that it's kind of a bit of a rough translation, and some of the irony or sarcasm is missed, is lacking in their rendering of that statement. So yeah, sometimes it can be appropriate. depending on. So that's a tough one there.
They should be rendering the tone, though. Am I right, Adam? The appropriate tone.
They should be rendering the tone, exactly. We're supposed to be conserving like the register, like is it informal language, formal, the tone, exactly. I mean, it's a bit of a judgment call there for the interpreter. If they have, it's a tough one. I'll have to think about that one some more. Let's see if I can come up with a better answer by the end of this, but think about that one a little bit more.
Okay, thank you.
Mhm.
And I'm nearing the end of the list that I've been sent, so feel free to add questions to the chat if anyone has one. But the next question is, do class interpreters ever use the simultaneous interpreting channel on WebEx?
No, we don't. We currently don't. We tested it and it didn't work as well as we needed it to be. We do have a system where we trained using a third channel, like how Adam and I called each other. We do have a way to do simultaneous though, and we have trained most of our Spanish interpreters, at least, and some of our languages other than Spanish interpreters on how to establish that third line and how to do simultaneous on WebEx. So in the notes, when you're requesting for interpreter, you can actually ask WebEx, could I have an interpreter do simultaneous interpreting? And then we can make sure it's somebody who's trained in how to do it and how to set it up.
Okay, great, thank you. And then this one might be kind of tough, but we'll see. Okay, this question from Tom. In California, we had to swear in the interpreters before starting. Do we need to do that here in Oregon? Or we don't need to do that here in Oregon, right?
For mediations and arbitrations, Adam, have you ever seen that done when you've done a mediation or arbitration? I know in court when you do, but
In court, it's always it is required. Typically in the way it works in court is that, like, if I say I'm certified, the judge doesn't go into an extended long colloquy about my credentials. But if I'm not certified, let's say like I'm kind of like on the path to certification, and I have some experience, the judge in their discretion can ask me to give a longer explanation about my credentials, meaning like what's my education background, what's my experience in interpreting. They may require a longer explanation like that. As far as mediation, I'd have to ask our boss at Aledo, the head of court language access, what the requirements are in a mediation as to like what to put in terms of our credentials, if we should always establish our credentials. I think it probably would be a good idea as a best practice that we establish our credentials at the beginning of a mediation or arbitration, just like we do in court. I think that sounds like it, but I would have to ask if there's like an actual rule regarding that.
I don't think there's currently there is no actual rule or requirement, but like Adam said, I think it's best practice to always ask for the credentials at the beginning.
And as I said, yeah, if the interpreter says that they're not certified, then that you should you could ask for more information. And that if they've worked in Oregon, they should not find that unusual at all, because judges do that all the time. So if they get offended by it, then let class know, and class will deal with that. They'll just politely instruct the interpreters not to be offended by something that is a very routine and normal thing to do. Yeah.
And we do have a roster on, well, I mean, if you have a question about a particular interpreter, let's say that you hired on your own, you want to check if they're credentialed here in Oregon, you can always give us a call and I can check the roster to double check.
Okay, I know we're nearing the end, so I did see the feedback about if a party checks a box indicating a need for an interpreter, that the court should relay that to the arbitrator upon appointment. I don't know that that is happening everywhere. And so if you have feedback for your local court, you can certainly provide that to your local court. And also that might be something Megan and I can look into in terms of offering all courts some feedback on that. The last question that we have are, what do interpreters need mediators to know? Any last, final, best recommendations for working together?
You want to take that, Adam?
I think I would just reiterate some of the things that I said before about how we need, like, if we're by ourselves, we need regular breaks. And you should even encourage that as a mediator, like encourage us to take regular breaks. It's unusual if we're not taking a break after an hour to an hour and a half. Because as I said, the quality, according to the neuroscience and the studies that they've done, our quality level goes down at 30, like a substantial drop after 30 minutes. So we should be taking regular breaks. That's a good thing. Probably a good thing for all the parties too, right? To just take a break and take a breather. Because it can be a little bit long, it can be a little bit tiring when you're doing the consecutive mode. Things tend to be a little bit longer. Think of anything else that sometimes, yeah, and also, again, like I said before, from time to time, we may need to look up a word. That's not unusual either. We're not walking dictionaries. So there are some of us that are walking dictionaries, but some of us may need to look up words or terms. Sometimes we blank on something. Everybody does that every once in a while. We need to look up a term again.
Adam, someone added a follow-up question. Is a 5-minute break enough, or would you recommend a longer break?
It just depends. I mean, like if a 5-minute, I think after about an hour, like 5 to 10 minutes, after about an hour, it's about like 5 to 10 minutes. I would say. And if it's a very long session, like an hour and a half to 2 hours, then the breaks should progressively get longer and longer. I mean, like maybe like 10 minutes, 15 minutes if it's a very long session. We just need those regular breaks. Like even like 5 minutes, it will improve our interpreting, the quality of interpreting substantially. Like just to have those short breaks. So, but yeah, 5 minutes should be enough if it's just like you're breaking like half an hour in, 45 minutes in.
Okay.
Yeah.
Thank you, Yvette and Adam, again for your presentation today and for your work over the last year to improve language access services for court cases involving mediation and arbitration. And of course, thank you everyone for your time and participation today. I know I learned something new. I hope you all did too. As we wrap up, I'd invite you all to write down one takeaway from today's presentation. Feel free to throw that takeaway in the chat too. For me, it was to pin the ASL interpreter in a remote setting. I did not know that before, so thank you for the information. If anyone has questions after today's session about accessing court interpreters, using LanguageLine, or if you have questions about future webinars, please reach out to me. I'll put my contact information in the chat now, and it's also on the screen in front of you. Emily already put the link to the chat to the SurveyMonkey. Emily, could you throw that in there one more time so it's at the very bottom? We invite you all to complete the survey and to test what you learned. There's a couple pop quiz questions so you can see how well you paid attention today. Attorneys, it is really important if you could please take a couple minutes to fill out at least the first 2 questions of the survey so that we're able to report your attendance to the Oregon State Bar. Non-attorney mediators, today's webinar does qualify for mediator continuing education hours. As Megan mentioned earlier, we're going to send more information about a new electronic system for courts who have asked us to provide support for continuing education reporting. So please check your email for more details about that after today's session. And we are hopeful that we'll be able to offer at least one more ADR webinar before the end of the year. So stay tuned for those announcements in your email as well. Thank you again, Yvette, Adam, Emily, and Megan. I hope you all have a wonderful weekend. And of course, go Ducks. Take care.
Likewise. Take care.
Thank you. Thank you.
Thank you for having us. Yep.